affectionately known as FAMLI. I'm joined today by several members of our policy team, and they're going to be helping us to answer your questions. Today, we are going to be focused on some of the family rules that have been adopted recently, and we want to make sure that employers understand them and hear what they need to know about them. We also want to hear your feedback on FAMLI. We will be opening this up to questions towards the end of the hour, and we'll get to as many questions as we can. For some quick housekeeping for you, this presentation will be available for you on family.colorado.gov shortly following the webinar. All the links to the rules that we'll be discussing today will also be available for everyone who has registered. If you have questions that you would like to ask, please put those into the Q&A function that you can see at the bottom of your screen. We have disabled the chat function, but we'll be happy to respond to questions in the Q&A function. Our team of panelists are going to be sharing some helpful links as we work through today's conversation, and they will be put into the chat for you. And you can also find recordings of any of our previous webinars on our YouTube channel, and they cover a variety of different topics going back over the last 12 months. Next slide. A quick look at our agenda today. We'll be covering several new rules that will affect both employers and employees taking family leave. These rules include the details on retaliation, interference, job protection, reinstatement, investigations, appeals, the coordination of benefits, our program's integrity, or what happens when someone underpays their premiums or overcollects on benefits. And then we'll be wrapping things up with a poll that is an interactive part of our webinar today. So we would love to get your input from that. And then we'll be opening up the floor for your live questions. Next slide. So first things first, here's where you can go to read all of the rules that we'll be discussing today. They are linked on the agenda slide, which again, you'll be receiving through your email when this webinar is over. You can also find them on the FAMLI website. It's the 4th tab over under Proposed and Adopted Rules. This is where you can see the rules and also get an early look at the rules that we're proposing. Any proposed rules are open to public comment, and they'll be posted here. And believe me when I tell you, your feedback really is incredibly valuable to us. We do want this to be a process where we get input from our community, and we hear from employers and employees about the rulemaking process. When there is a proposal that won't work for you or for your business, it's so much easier for us to try and fix that before it gets adopted. So please do keep an eye out on that page and make sure you know what's coming up and how you can tell us what you're thinking. Next slide. I'm going to pass this over to David. He's with our policy and compliance and appeals and all things legal team, and he's going to walk us through the next few slides.
All right, excellent. Thank you for that introduction. First thing we're going to talk about today is retaliation against employees. So as a reminder, the FAMLI Act was passed by Colorado voters in 2020 by a margin of about 60%, or about 60% of Colorado voters voted for it, which is a pretty big winning victory in today's world. But what it says is that employers can't retaliate against employees who need to take some time away from their job because of significant life events. Things like the birth of a child or a serious health condition for themselves or a family member. But what does retaliation mean? So let's break it down a little bit. Retaliation is really any type of an adverse job action. So anything that's going to hurt that employee's status within their job. So demotion, termination, pay cut, denial of opportunities that happens based on a protected activity. So there are lots of things that can be considered protected activity. In large part, what we're going to be looking at is cases where people request or take leave, but it can even be broader than that. The FAMLI Act does protect people talking about family. So if, say, for example, an employee sends out an email to their coworkers saying, hey, did you all hear about this great new program that will let you take paid leave? And the employer says, you can't tell people about that, you're fired. That could actually be retaliation as well. But most of the time, what we're expecting to see is retaliation for people who are requesting or taking leave. But you can find the other examples of what that might be in the full rule, and that's on that website that you've already got there in the link. Uh, but there's a couple of big examples here on the slide. First, an employer can't discipline or dock the pay of an employee who's facing a covered life event and files for family leave for taking family leave. And we'll talk a little bit about some exceptions to that later, but that's the easy thing, right? If somebody says, I'm taking family leave, your response should be, okay, not you're fired. If it's you're fired, you're probably going to have to come in here and talk to us and some of our investigators. For any workers who have been on the job at least 180 days, those employees must be reinstated to their old jobs when they return from leave. And we'll talk a little bit more about reinstatement when we get a little bit further into the presentation today. But yeah, somebody's allowed to come back to their job. They can't lose their job because of the leave that they're taking if they've been with that company for 180 days. It is considered also confidential information when a Colorado worker tells their employer they need access to paid family leave and why. This is something that unfortunately I've seen in other areas. I used to work in workers' comp, and we would sometimes see cases where somebody would have a workers' comp injury and some of their medical records would be distributed around the office. It ends badly. It's not something you want to do, and it's something that we would consider retaliation. So let's go ahead and then move on to the other aspect of this, which is interference. This is something else that voters said employers can't do. You can't interfere with workers trying to file for family leave. The rule defines what interference looks like, and you can go look at that rule. It is a pretty broad definition. It's really anything that an employer does that tries to prevent somebody from requesting leave. And it doesn't have to be intentional. Anything an employer might do or fail to do that interferes with the right to take family leave can put that employer in hot water. This is why employers have requirements on notifying employees of certain things, like those mandatory break room posters. And also, if an employee comes to you and says, I need to take FML under the federal law, you got to notify them of the paid family medical leave, which you want to do anyway, because you want them to get onto the federal FML job protection and the paid family leave concurrently. That's going to work out better for you. But a couple more examples. Anything that can be interpreted as threatening to an employee who needs family leave can be a problem. Like, gee, I'm really sorry that's happening in your life, but if you step away from the office for 12 weeks, that could really hurt your promotional opportunities. That's interference. Could also be retaliation. Misinformation about the program is also a problem. We've already heard of some employers who are telling their employees, oh, well, we don't recognize that program, or we don't allow paid leave. That could be a problem. Telling people, giving people the impression ahead of time that they're not going to be allowed to take leave is going to be interference. There's something very specific in both the statute and the rule that I want to address, and that is immigration status. Non-citizens who are working in Colorado, they're paying the exact same premiums into the insurance fund as citizen employees, and they can access benefits the same as any other worker. So if there's intimations, outright threats that action might be taken against somebody's immigration status, that's going to be interference as well. And that's something that we're going to take very, very seriously. So, something along those lines of, hey, if you take this leave, I'm going to have to go talk to somebody about your visa. That's interference. And we'll be taking a very harsh look at that. Let's go ahead and take a look then at some things about reinstatement. So it sounds like employers have a lot to be scared of in these rules, but they don't need to be. Facilitate your employees taking leave. If you do that, you don't have much to worry about. And I'll tell you from taking continuing education courses in FML or the FMLA and other employment law areas, the stuff that employers do that get them in trouble, normally when somebody talks about it, there's gasps in the room. They can't believe that an employer would do something like that. It's actually really easy. If somebody says, I need leave, say, okay, go file for your leave from the state. We're going to be the ones who make that determination. So let them go file with us and we'll take a look at it and we'll make that determination. Facilitate taking the leave, but there are some important protections that employers should be aware of. So already mentioned, employers are required to reinstate employees to the positions they held when they started their leave. And they still are counted as an employee while they're on leave, so long as you expect the employee to return to work, which we do because there's job protection there. So that's if we're counting the number of employees that you have, which we do for premium calculations, they still count as an employee. But that doesn't mean that anyone who has a baby or a sick family member or who is out on leave and receiving benefits from us can't be fired. You're not obligated to overlook performance issues that aren't related to the paid family leave. So, something I used to see when I did workers' comp, we'd have somebody who was out of the office, they were out on leave, they would get mad about something, send a obscenity filled email to their boss. That's a grounds for termination. So if somebody has these performance issues, if they have other issues that they could be terminated for, you do still have a right to terminate them. Very general HR advice here for everybody: document. Because if this person comes in and files a complaint, we're not necessarily going to know why they were terminated. So when we come out and say, hey, why were they terminated? Make sure that you've got that good information to give us so that we can see what happened there. If you reorganize or eliminate some positions that would include people who might be out on family leave, you don't have to recreate a job. So if you go through a force reduction, you're doing layoffs, you lay off a third of your workforce. That can include people who are out on family leave. What you want to make sure you're not doing, though, is specifically targeting those people. Like, well, let's lay off everybody who's requested leave in the past year. That's going to be retaliation. But you can still amend your workspace. You can still alter your levels of force. You can still do all of that when somebody is out on the family leave. You just can't target them. You can't do anything specific, and you can't go after people for using the leave. Another point here is that employers are not obligated to reinstate employees who can no longer perform essential functions of the job. So you've got somebody who has a serious health event, they're going to receive state benefits while they recover. But at the end of that 12-week period, if they're not recovered to the point where they can come back to work, they don't have to be reinstated. So, if you have somebody who has a very unfortunate accident, they have a traumatic brain injury, they're in a persistent vegetative state, you don't have to reinstate them. They do have to be able to, at the time their leave ends, come back and actually do the job. Now, a word of caution here. I'm not here today to talk about ADA requirements. Look into that and talk to your HR department, counsel, and make sure that you're in compliance with other laws that may govern that. But underneath our law, there's no requirement to reinstate. So let's then move on to the next slide and talk a little bit about seasonal workers. We get this question in Colorado a lot. Unsurprisingly, we have a lot of seasonal workers here. There are a lot of people who, they're ski instructors until the snow melts, and then they're rafting instructors till the snow starts falling again. So in order to get benefits, workers only have to show that they've earned $2,500 in Colorado income in the past year. So that's a pretty low threshold. So a lot of these seasonal workers are going to meet it. They're going to be entitled to benefits. But their employers are not obliged to reinstate seasonal workers to jobs that they left at the end of the season. So let's talk about ski country. We got some ski instructors out there. You got an employee who works at a ski resort. They've got to step away in March because they've had a qualifying life event. So they're out on the paid family leave. They get the full 12 weeks of benefits that they're entitled to. And now they're ready to come back to work, and it's June. Not a lot of snow out there, right? Ski resort doesn't have to turn on the snow guns. They don't have to pretend it's winter to give this person their job back. Seasonal jobs that were already scheduled to wind down at a certain point are not required to reinstate a seasonal worker who took family leave mid-season. But I'm going to say, we're going to take a look at this. And if at the end of that person's leave, those positions are still open, you're still operating a ski resort, let's say it was the beginning of the season and they didn't take the full 12 weeks, then they're going to be obliged to return to their job, or you're going to be obliged to return them to their job. So pay attention to that, but do know that if you've got a seasonal job, you don't have to recreate it or try to work some sort of weather magic to bring this person back to work. If the job ended while they were on leave, then they're not required to be reinstated. So what happens if somebody violates one of these laws? How are we going to investigate complaints? Someone calls us to report a complaint, or they do something online, we get that tip. We're going to give them a form to fill out. Once we give them the form, they've got 35 days to get the details back to us. That is not a harsh statute of limitations. It's not like, oh, if you don't return that form, you're done. We'd probably just resend them the form and that would start again. So don't think that if it's been 35 days, you're out of the woods on this. Burden of proof, though, when they fill out that form and they give us that information, the burden of proof is on them to demonstrate that there was a violation of the law. The aggrieved individual is responsible for proving their employer was in the wrong. The employer doesn't have to show, doesn't have to prove that they followed the law. Now, if an employee does show that an adverse employment action occurred, the employer does need to produce some evidence showing that it occurred for a legitimate reason. If you have any familiarity with employment law, yes, this is the McDonnell-Douglas burden shifting scheme. So what that means is that the employee has to come in and prove that something bad happened, that there was an adverse action, and that they were covered under the act. But then the employer can come in and just produce some evidence to show that there was a reasonable basis for it, a non-discriminatory and non-illegal reason. And then we look at that. Once we get that complaint, though, we're going to have 60 days to either investigate it or to dismiss it. And if we investigate it and we do find that a improper retaliation or interference occurred or a failure to reinstate, then we're going to take some action on it. So what's that action going to look like? We can go ahead and move on to that next slide here. We can impose a fine. We can go tell people, hey, you committed retaliation, you committed interference. Here's the penalty that we are going to impose for that. Once that happens, employers do have a right to appeal it. You got 45 days after that final decision to file an appeal. There's an appeal process spelled out in rules. All it really has to do is a written statement that explains the clear error in the determination. Sign it. You don't need a lawyer. You can definitely have one if you want. You're entitled to representation of your choice, but you don't need to do that. You just have to give us something in writing that explains where we went wrong. And give you an example here. A couple of years ago, I was working in a different job. We got a complaint that we had committed discrimination. The address where this discrimination happened was not our address. The name of the person who engaged in the discrimination wasn't anybody who worked for us. It was dismissed, but if it had gone to a fine, we would have been able to demonstrate clear error pretty easily because the person who was making that complaint was making it against the wrong people. I don't know what happened. All I know is that that person was not in our building and it wasn't anybody who worked for us. So that can happen. I'm hoping that's not going to happen with us. Our investigators should be doing a better job than that. But you can demonstrate that. You put that out, explain why we're wrong. It'll go in front of one of our hearing officers. They're going to make a determination. So there's some other elements here that we do want to talk about. So let's go ahead and move on and talk about coordination of benefits. So put aside the retaliation, interference investigations. We also have some new rules on how family interacts with other benefits. So two of the biggies, unemployment insurance and workers' comp. We're not going to go through every possible example here. I'm a huge workers' comp nerd. I want to leave time for questions, and that's not going to happen if I start digging into this topic. But the big thing, you can't double dip on these. In order to get unemployment payments, you have to be able and available to work. The whole thing about family is that you have some sort of qualifying life event that is preventing you from working. So you can't get them at the same time. Workers' comp benefits, particularly temporary benefits, you're receiving those benefits because you can't work because of a work-related injury. Same deal. You can't get family benefits for not being able to work while you're being paid out of workers' comp. So you can't do that. You can't take both benefits at the same time in most cases. But let's talk a little bit about paid leave that employers provide. And I've seen some questions pop up already about this. So let's say an employer has unlimited time off. So they get full pay if they need to step away from work. They have a short-term disability program that will step in and that will provide benefits. That doesn't impact anybody's entitlement to family benefits. So if somebody comes to us and says, I've had a qualifying life event, I need family leave, I need family benefits, we're not going to look at employer provided leave. We're not going to look at your PTO policy. We're not going to look at your short-term disability program. We're going to determine if they actually qualify for leave, and then we're going to award it. What that means, though, is that you as an employer can modify those programs. You're not responsible then for that. You can amend your PTO program and say, hey, we're not going to pay you pay out PTO if you're on family benefits. You can work with your short-term disability provider for how they're going to coordinate those benefits. There are some employers out there who are going into kind of a make whole program because family is only a partial wage replacement. You can consider if the family program is a good substitution for that short-term disability. A lot of employers in the states that have enacted programs like this already really like the paid leave insurance because it's a cost savings for them. They are reducing those benefits that they're paying for. And that was one of the arguments that was made when the FAMLI Act in Colorado was on the ballot, is that this is actually going to save employers money because you're not necessarily going to be providing those benefits. You can let us pay them. We cover wage replacement with premiums that have already been paid. We take on that administrative burden of verifying medical conditions and doing the investigation and reviewing all that documentation. So you can modify your benefits programs to take into account family. So the last rule that we have is program integrity. So let's go ahead and take a look here at the next slide for that program integrity. So this is a fancy way of saying, how do we keep the ship afloat? So we're funded by premiums. So everybody's paying into premiums. That's what funds us. It funds the benefits we pay. It funds our operations. We want to make sure that we are paying out the appropriate amount of benefits and that we're receiving the appropriate amount of premiums. So benefits can be overpaid. Somebody can get more than they're entitled to. Premiums can be underpaid. Somebody could not report the appropriate wages that they've paid. I think there are probably some employers out there, very few, but some, who just aren't reporting anything to us. And that's not fair to the people who are participating in the system the way they're supposed to in accordance with the law. So we are going to be taking long, hard looks at that to make sure that we are getting those overpayments back and we're getting the proper premium payments. So if we get a tip, find out through an audit that there may be folks out there getting family benefits they shouldn't qualify for, we are going to investigate and we can recover those overpayments. We're also going to be investigating employers who might not be paying the premiums they owe. Either they're part of the premiums or the premiums that they can deduct from their workers. Same goes for private plans, by the way. So if you've elected to be covered under a private plan, that private plan has that same right to recover overpayments. So they're going to be stepping into our shoes and acting in our place. They are authorized to investigate fraud and to collect damages. But here's the key. If there's an overpayment of more than $25 that they're attempting to recover, they do have to let us know about it because we want to figure out why that overpayment happened. And we are also required by law to consider the impact of recovering that overpayment. And we want to make sure that we're doing that there. But that's basically it for program integrity. We're going to be out there making sure that everybody's playing by the same rules. Nobody's receiving more than they're entitled to, and everybody's paying what they're supposed to. And so with that, I'm going to hand it back over to Tracy for our wrap-up poll.
Thank you so much, David. And huge thanks to David, Evan, Mona, and the rest of our policy team for putting together a really, really solid set of rules around this. We know it's not easy to track with, but this is important that we release all of these to you before benefits go live. So thank you for getting those taken care of. All right. So there's no doubt that you're going to have some questions, but before we dive any deeper into those, I'm going to hand us over to Jessica, and she's going to have a poll for you today. Jessica.
Thanks, Tracy, and thanks to everyone for joining our webinar. Before we get to your questions, we have some questions for you. We have a quick poll today with 2 questions. I've launched the poll, so the questions should pop up on your screen, so feel free to answer those at any point. But the 2 questions are basically, we just want to learn how you've heard about FAMLI, what tools are working for you, and what your understanding is of the program. That'll just help us continuously improve our communication tactics as we get closer to the launch of benefits. So I will go ahead and leave that poll up for everyone to participate. And in the meantime, I will head over to our questions. And thank you to all of our policy team and contact center representatives who are on the call today, already answering 25 questions in the chat. Super helpful. Keep those questions coming. We have about just over 30 minutes to answer more questions. So we'll take the first one here, an anonymous question. It just disappeared. So our team is just going so fast and answering these questions. Here's one. When will the FAMLI employer portal be available? The COB portal be available? I think you might be referring to benefits. The employer portal is already available, but Tracy, I'll hand that over to you so you can talk about how employers will integrate with benefits once their employees start applying for leave?
Yeah, absolutely. So there is going to be a portal specifically for employers. Well, you'll be able to go into that portal and see on one screen where your employees are taking leave and at what point in the process they are with us, whether or not that leave has been approved, what you can anticipate as their return to work date. All of that information will be available for you on one screen. Our goal is to have that available simultaneously with when we launch for benefit payments, and we anticipate that being in Q4 of this year. I'm reluctant to give out a firm date because I don't want to make promises that I potentially can't keep, but it will be in Q4 of this year.
Thanks, Tracy. Here's one that's semi-related. Does the employer need to create portal access to FAMLI? So if you could elaborate on the two portals that you just mentioned and what employers need to do to get access to those portals.
Yeah, absolutely. So yes, you will need to have access to My FAMLI Employer Plus, or My FAMLI Plus Employer, I apologize. And that's what you're in right now, I would hope, right? You should be registered in that system. That's how you're uploading your wage reports to us. That's how you're making those premium payments to us. All of that will still function in the same way. Behind the scenes, our technology whizzes are also creating a portal view that will allow you to be able to see that list of employees that I mentioned. As to whether or not there's a separate registration for that, that is something I would probably need our tech team to keep me straight on. I don't have that answer at the tip of my tongue. So Corey, maybe you do.
I was actually just to jump in because Sylvia asked a similar question. There will be a separate login. We will definitely have a separate persona, but we are working on creating a HR benefits portal for individuals and partitioning the data effectively so that we make sure the right people have the right information at the right time without giving them wage data and personal information that they don't need. So I don't know if that helps answer that question a little bit more.
Well said. Thanks, Corey. So it's going to be on a need to know basis, right? We're going to make sure that the people that need to know have, right in time information and get what they need when they need it, but don't have access to things that they have no need to see.
Exactly.
Thanks, Tracy and Corey. I have a question here for David. Do out-of-state employers with 501c3 status use the same site for registration?
Absolutely. We got one site for all employers. So if you are based in Colorado, if you're based outside of the state, if you're for profit, if you're nonprofit, you're all going to use that same portal.
Thank you, David. We have an anonymous question here that we haven't touched on yet. For self-funded plans, how do we get the surety bond? David, can you take that?
Yeah, so surety bonds are obtained from third parties, and I do believe we've got some resources on our website for the companies that are authorized to provide those surety bonds. You can reach out to them and make those arrangements. They will tell you what the cost of that bond will be for you, and then you can give us that information and give us the bond, and you can move forward with being self-employed.
Thanks, David. We do have some resources on our website. If you go to the employer FAQ page, there's a question on there. How do I find a self-funded or surety bond vendor that's approved by the state? And we have a step-by-step instructions so you can look through those vendors that are already approved. Here's another question for you, David. What if an employee is not eligible for the federal FMLA? How are they job protected?
Yeah, and so that's a great question. Federal FMLA applies to employers with more than 50 employees. The Colorado FAMLI Act applies to every employer. So there are going to be a lot of businesses out there that do not fall underneath the federal law, but are going to fall underneath the state law. In those situations, the employees are going to be covered under our state law. They're going to have that same job protection, and particularly that right to reinstatement, provided that they've worked there for 180 days. So those smaller employers are still going to have to return people to employment. There are also some differences in terms of overall eligibility between the federal law and the state law. We do look for 180 days. The federal law looks at specific number of hours worked. So you could have individuals who are eligible for Colorado job protection, but are not going to be eligible for federal protection. Now, that's going to be the big group there is going to be the people eligible for state level protections. There's going to be more people who fall under that umbrella than under the federal umbrella. But if you do have somebody who is eligible for both, they can run concurrently. They should run concurrently. So you want to take those efforts, make sure that you're getting the documentation that you need under the federal law to start that clock up, and get them signed up with us to start our clock as well, so that those two leaves will run concurrently.
Thanks, David. We have a question here from Melissa. How far in advance will the employer know when an employee has requested leave through the state's portal? This is important to know when an employee is out.
Yeah, and so that's going to vary. Basically, you're going to know very quickly when somebody comes into our portal. They're going to tell us who the employer is, and we will notify you once it's been approved. We look at it and we'll tell you that, yeah, we've approved leave for this individual for this length of time. We do ask that that notice be given as soon as possible, and we really do want to see it at least 30 days out. But there are emergencies. There are emergency life changes that have to be dealt with. And so you'll get it as soon as we make that adjudication, but I can't guarantee it'll come out early.
Thanks, David. Here's a question for you. Are temporary employees or summer interns eligible?
Absolutely. And that would fall under that same discussion we had of seasonal employees, but they are still eligible. But if you have somebody who is on a fixed time frame for how long they're going to work, they don't have to be reinstated if the leave extends beyond the end of that.
Thanks, David. We have one here from Michael Santo. Hi, Michael. Thanks for joining us. This is a scenario he's outlined. Let's say an employee goes out on family leave. While that employee is out on leave, awaiting to hear back whether their leave has been approved by the state, the employer advances the employee's wages for that period, i.e. does not provide the PTO leave for that time. Then the employee gets approved for the state leave, including the period of time the employer advanced the wages. If it had been PTO, the employer would be required to get the payment back from CDLE. But since it's an advance on wages, can the employer get it from the employee?
Yeah, so that issue of what happens with those wages is really an issue between the employer and the employee. So that can well happen, particularly under that circumstance I was just describing, where, you know, something happens, somebody has an emergency situation, so they're out of work, they are missing work, but at that time they've also filed for benefits. We approve it, and there's kind of a retroactive thing there, like you've been out of work for 2 weeks by the time we have processed everything. So you're going to get benefits back to that first day of leave, and during that time, the employer has paid for that. So recovery of that, if it is subject to an employer policy, is going to be subject to that agreement between the employer and the employee. I would advise check in with the Department of Labor Standards and Statistics about your ability to recover those wages. Make sure you're not running afoul of any wage and hour laws, but the family program doesn't have any involvement in that.
Thanks, David. And here's another question that I'm assuming is connected to a local government employer. Marilyn is asking, what if you have opted out of family, but you have employees who choose to voluntarily participate in family? Can that employer still access the portal?
You know, I would ask if there's somebody else who can weigh in on that. Our approach has generally been that if that employer has completely opted out, the relationship is between us and the employee. But I see a hand up from Evan, from one of our policy gurus.
Go ahead, Evan.
Well, so the potentially helpful answer is that they will have to access that portal to opt out in the first place. Is that still correct?
That is correct.
So if that's correct, will they still be able to utilize the portal for that? So that's where I get into what I don't know for sure is if there's particular permissions or something once you're registered. That might be something for Anne that I think of it.
Yep, I can answer that one actually. So They will have to register. They will have to have a private plan opt-out administrator who will have access to that account. So employees or local governments who opt out have a couple of options. They can either opt out completely and not remit on behalf of their employees. They can also remit on behalf of their employees, which means they don't have to pay the employer side of the 0.09 wages. So long story short, yes, you still have access. You will have an administrator who has to submit the request for opting out, and then the elected individual will have to sign in and link themselves to that account.
Thanks, Corey. We have a couple questions coming in from our YouTube audience that I want to get to. David, if you can take this one. Mo is asking, what happens when someone takes FAMLI, comes back to work, and then quits, gets fired, or gets laid off? What, if anything, is the responsibility of the employee and employer in that scenario?
So in terms of responsibility, not a whole lot. In terms of my very, very strong recommendation is document what's going on there. So, if somebody comes back in and they say, you know what, never mind, I don't like this job anymore, I quit, make sure you've got a good documentation of that. If you're going to terminate them, you're going to fire them, you're going to lay them off, whatever, make sure that you're prepared to explain to us what happened. So, it's one of those things you learn your first day of law school. Anybody can sue anybody for anything, right? But the question is, does that suit go past the first day when it's filed? And so if somebody comes back from leave and 2 days later, they're terminated from their employment, I can expect that they're going to come to us and they're going to file a complaint. We're then going to come to you and say, what happened here? And it's going to be some pretty high level of scrutiny there, because that does look really suspicious if somebody's fired 2 days after they come back from leave, or 3 days. Don't think I'm giving you a deadline here, right? This is a gray area, but we're going to be looking at it if there's temporal proximity. So you want to be prepared to let us know, like, why was this person fired? Was it a performance issue? Do you have that documentation? Was it a behavior issue? Do you have that documentation? Was it a layoff? Was it a force reduction? Can you explain to us why that happened and who all of it impacted? Was it just this one person? Was there a reason for that? So there's not any real bright line I can give you on what to do in that circumstance. Just know that it is possible, probably likely, that that person's going to file a complaint. We're going to investigate and be prepared to show us what your side of that story is so that we can get the full picture. We don't want to take actions based on what one party tells us.
Thanks, David. We have another question coming from YouTube. Tracy, I think you can take this one. What is the percentage of pay that is covered for someone that qualifies? Is it 100%?
It will not be 100%, but it is on a sliding scale. And that's something that you can certainly find on our website. And I'll have somebody hopefully put that into the chat for you. But it's on a sliding scale calculator based on your level of income. There is a maximum benefit of $1,100 per week. And for some people, they may be receiving as much as, 80% of their income, even higher. And there may be other people who are receiving maybe 30% of their income replacement. So again, it's on that sliding scale, but we will post a link for you to our calculator.
Thanks, Tracy. We have another question from our YouTube audience. What about using FAMLI with reduced hours under FMLA? Are the benefit limits the same? David, can you take that?
Yeah, so the benefit limits are the same, the maximum benefit and the calculation, like Tracy was just saying about the percentage of the benefits that will be paid. But you can take intermittent leave or a reduced schedule leave. So if somebody is, say, they've got something going on and like, well, you can only work 4 hours a day instead of 8. You're going to work your 4 hours, you're going to get paid for those 4 hours, and we're going to calculate your benefits based on those other 4 hours that you're not working. So you would get a partial benefit, still subject to those limitations, but that's how it's going to work. We're going to look at the actual wage loss and compensate for that.
Thanks, David. Here's a question about maternity leave. Is an employee eligible for benefits for maternity leave if they are not planning on returning to work after 12 weeks because they are moving? Would they still be eligible?
Yep. So we can't look at speculation. Even if somebody's absolutely certain about what's going to happen, we don't look forward like that. We don't anticipate those events. So if somebody comes in and says, I need 12 weeks of bonding leave to welcome a new child to our family, and they've got the new child, they've got the documentation, we're going to award that 12 weeks of benefits. At the end of that 12 weeks, if they tell the employer, I'm not coming back because I have moved to a different location, then their employment's terminated, but they were still eligible for that leave.
Thanks, David. Tracy, you can take this one from Franny. What is a turnaround time for approval? And now, Franny, we're assuming that you're talking about approval for benefits. There's also approval for private plans, things like that. But let's say you're talking about benefits. Go ahead, Tracy.
Yeah, if you're talking about benefits, then the approval turnaround time will be within 2 weeks. That being said, we must make sure that the person who is applying for leave does get all the required documentation into us timely. We can't make a decision if we don't have complete information. So that would mean we would need to have their wage reports turned in, so their employer needs to be participating where required and getting those wage reports turned into us. If the individual is self-employed, they'll also need to make sure they're providing us with the documentation around that. And then we would also need to make sure we have any necessary documentation, whether that's related to childbirth or a health condition, from the appropriate healthcare provider. So assuming that we have all of those elements that we need to be able to make a decision, our goal will certainly be to turn those decisions around and get payments out the door within 2 weeks.
Thanks, Tracy. David, I'm going to hand this one to you. Is there a more defined list of what family members you can take family for?
Oh, it is a long and intentionally vague list. So we are looking at close family members, but also individuals with whom there is a family-like relationship. So we're recognizing, it's 2023. There are a lot of living arrangements that don't necessarily match up with the way that Ward and June Cleaver did it. So if you have somebody who you're cohabitating with, but not married, that can be covered there. If there's a particularly close family friend, that can be covered there. We're going to be looking at a wide array of things for that. We're going to be looking at financial responsibility, healthcare directives, all sorts of things there. But it's not going to be an exclusive list. It's not like a blood relative within a certain degree of relationship. I always think about a gentleman who I always knew as my Uncle Alex, who had no formal relationship whatsoever to my family, but was pretty much my aunt's best friend. She was the executor of his estate. She had all of his healthcare decisions. We probably would have counted him as a family member for my aunt, who had that connection with him. So that's the kind of thing that we're going to be looking at. So it can be very broad. We don't have a very specific list, but if it's outside of that realm of those close blood relationships within, the first degree, we will be looking for some more documentation to explain what that family-like relationship is.
Thanks, David. And Kristen just dropped into the chat for everyone. We do have a recent blog post about our broad definition of family. So feel free to check out the link in the chat. Thank you, Kristen, for dropping that in. We have a question here from Darren that we haven't touched on in this session, but we've talked about quite a bit in our previous sessions. Remote employees who are not in Colorado, are they eligible or are they not eligible?
Yeah, and so it's a great question. There's a great resource on our website with a flowchart to walk through on localization. And every time I try to cover this from memory, I get a whole bunch of chats from our policy staff telling me how I'm wrong. So what I want to say is just go check out that flowchart. Basically, what we look at is, where does the person work? And that gets sometimes a little bit weird with remote work. But if somebody's work is localized in Colorado, they're covered under the program. If their work isn't local in Colorado, they may not be. But that flowchart can help you walk through the very specifics of your setup to see if they would be covered or if they wouldn't be. And I did see, there was another chat and a question in there about, is this for people whose work state is Colorado or who live in the state? And it really is that work state. So if somebody lives in Grand Junction, but they work across the border in Utah, Just because they have a residential address in Colorado doesn't mean they're covered. But you flip that around, you've got somebody who, let's say, lives in Cheyenne and they're driving down to Fort Collins every day and they're working in Colorado, they're going to be covered. But for the specifics of your case, look at that flow chart on the website. I can give you a general idea, but walk through it because you know the circumstances of that relationship and that employment structure.
Thanks, David. I have a question here from Kate. She has an employee that will be going on maternity leave in August. She'll be paid, the employee will be paid for about 5 weeks through the company's PTO. My company is not covered under PTO. She's planning to take FAMLI in January when it becomes available. Will she be entitled to the full 12 weeks in 2024, or will the 5 weeks of leave from 2023 be calculated in that as well?
She will be entitled to, presuming that the child is less than a year old for the first 12 weeks of 2024, she'll be entitled to the full 12 weeks. So in a very broad sense, the general sense here is that anything that the employer gives to the employee doesn't reduce the entitlement to family benefits. So people are entitled to their family benefits based on whether they have a qualifying life event. And we're going to be determining, if it's a serious health condition, what the appropriate amount of time for that would be up to that 12 weeks. If somebody's bonding, they're going to get the 12 weeks. Nothing that the employer does is going to reduce the benefits that somebody's entitled to under the Family Act. So what that means, though, is that the employer then has that flexibility to amend their programs. And I know we're in a little bit of a weird space right now at the end of 2023, heading into 2024, where our benefits aren't available yet. But once we get into 2024, this would be a circumstance where the employer could say, well, we're going to alter our policy on parental leave because you're going to be covered under the state. We're going to let the state pay for this. But yeah, in this case, the employer granting that leave and paying for it in 2023 isn't going to reduce the entitlement of the employee to benefits under the family law.
Thanks, David. A question here from Kathy. Please clarify the 5 or more employees who work 180 hours. If an employer has part-time college students, some who work less than 5 hours or less per week only during the summer, how would you qualify or disqualify this employer from matching the 0.45% match?
All right, let me break that question down a little bit. So what we're going to start with is the 180 hours, or that is the or 180 days. The 180 days is to be eligible for job protection. So if somebody has worked, if it's been 180 days of I'm here, I'm working since they started, they're eligible for job protection. Regardless of whether or not their job is protected, while they're out on leave, they're still counted as an employee for you. But when we count employees, what we're looking at are people who worked during a week for 20 or more weeks. So that's how we count it. So if you have somebody who comes in every Monday for 20 Mondays, they're an employee, and they count towards, it's actually 10 employees for whether or not you've got to pay the full premium or just the half premium. So if you have somebody who they're working 5 hours a day, but they work 1 day a week for 20 weeks for 5 hours, they're still going to be counted. So if that person then goes out, they meet that 20. So let's say they work 20 weeks, then they go out on leave for 12 weeks. They're still going to count, even though they've been out for 12 weeks, they still count as your employee because they've met that requirement. They've worked for 20 weeks.
Thanks, David. We have a question here from Teresa that could use some clarification. Tracy, I'm wondering if you can take this one. The question is, where will I find documentation to be able to opt out? So Tracy, if you could clarify that only local government employers can opt out.
Absolutely. So there can sometimes be a little bit of confusion around the wording of this, but opting out is not really an option for the majority of employers. Everybody is required to provide paid family and medical leave in some way. Your options are going to be whether you do that through a self-funded, self-insured plan, which would mean that you as a business are taking on this responsibility. You have discussed it with us and shown us that you have a surety bond and that you can afford to manage this plan for yourself. That's one option. The second option would be to go through a carrier. That's more of a traditional kind of private plan where you have an insurance broker and a carrier that's helping you support that program. Obviously, you're welcome to participate in the state-run program, which is what we're here talking about mostly today. The only folks that are able to truly opt out, and this is the way it's been written into the statute, are those who are in local governments that have taken a vote noticing that they do wish to not participate in the program. Other than that, it would only be federal employees, and there's some limitations around railroad workers as well, but the specifics of that can certainly be found on our website. But ultimately, employers do need to take action and do something. If you are a private employer, you will be needing to provide leave for your staff.
Thanks, Tracy. Question here for David, and I see you typing furiously, so I want to give you a heads up. Of course, now it just disappeared, but we've answered this at length many times before. There's a question here by counting the owners. By counting the owners in, we have to pay the company portion for the family. We are the owners and do not want to participate. So can you clarify what owners need to do?
Yeah, and so the distinguishing thing for us isn't necessarily if somebody's an owner or not. So the question we're looking at isn't, do you have a formal ownership stake? Do you have interest in the company? What we look at is, are you free from direction and control? So if you've got a boss, if there's somebody who is telling you this is the job you do and this is how you do it, you have a boss, you are subject to their direction and control, we consider you an employee. If you are free from direction and control, if you're the boss, you decide what work you want to do, how you want to do it, and maybe in this case, you're telling other people how to do their work, then you're not an employee. And so you wouldn't necessarily be counted in that provision for the employees. You wouldn't need to pay premiums, but you're also not going to be eligible for benefits. And that's a key thing to remember there, because if you come back in a year or two and you file a claim for benefits and you've been asserting that you weren't an employee, there's probably going to be some retroactive amendments to your premium liability there.
Thanks, David. Here's another question that we haven't exactly covered yet. How is the benefit amount calculated for part-time employees based on the hours scheduled to work or the paid wages for a certain period?
I was told there would be no math. So no, what we're really looking at here is wage. We're a wage replacement benefit. So we'd be calculating it based on the wage differential.
Thanks, David. Another question. My employer has vaguely said they haven't determined how they will employ family leave in the coming year, including who will be eligible. Can they deviate from your guidance?
Nope. If you want to DM me the name of your employer, I will get it to one of my investigators. I'm joking, kind of not, but also kind of. Yeah, so the rules are, this applies to every employee. So there can be some leeway there. You know, if you've got somebody who is, as I was just talking about, the free from direction and control, who might be considered not an employee, they can make that decision. You know, are we going to include this person? Are we not going to include that person? So I don't want to come out and right away say like, oh no, that's not allowed, because there is some leeway there, but it's very specific. In general, every employee is covered under FAMLI. They are entitled to use this benefit. Premium should be being paid for that employee based upon their wages. And it's not up to the employer to make that determination on who's eligible or who's going to be covered. This applies to everybody. Now, what an employer can do, and what I know that there are some employers out there who are doing, is decide to go with a private plan. And what those employers should be doing is, right now they should be paying premiums, but they will sometimes elect not to deduct any premiums from their employees. They will just pay the whole premium while they're waiting for that private plan approval. Because if they get that private plan approved before October, we're going to refund the premiums. And it can be easier for that employer just to get the refund of the money they paid without worrying about anything for the employee. So there can be employers out there who are making decisions right now about, we're not sure how we're going to implement this, or we're looking at private plans who might have some ambiguity in the future. So they could still be making those decisions, and that's perfectly legitimate. But in general, no, an employer cannot deviate from our requirements.
Thanks, David. We have just a few minutes left. I know we have a lot of open questions. We won't be able to get to all of them in 4 minutes, but we'll try to get to a few more with a few minutes that we have left. Here's a question from Terry. If an employee retires after paying into FAMLI, but doesn't use any of the funds or just partial funds from the FAMLI fund, what happens to the premiums and the company had paid in under that employee's social security number?
So, like I said earlier, we don't speculate on what's going to happen in the future. I know in my family, I have several relatives who took 3 or 4 attempts to retire. And so somebody could come in and say, well, I'm going to retire. And that means I'm not going to get to use these benefits. They could come back into the workforce in a year, and then they might need those benefits. But really what it comes down to is we are an insurance product. We are an insurance program. We insure against a risk. That risk is that you're not going to be able to work because you experience a qualifying life event. And like all insurance, it's something that you pay into with the hopes that you're not going to need it. It's like car insurance. If I don't get into a wreck, I'm not going to get that money back from Geico. I've paid for the protection that they've provided me in the event that I suffer that risk. So individuals who are paying into the FAMLI program right now are paying for that protection in the event that they experience a qualifying life event and need to claim these benefits. They need to claim that coverage. If they don't claim that coverage, mazel tov, congratulations on your good luck in your life. But you've been protected. So if you did have that, you'd be able to draw those benefits.
Thanks, David. I think we can get to one more question. Here's one that we've covered, but not in this particular angle. Maternity leave and paternal leave have been used as examples that may carry over into 2024. I assume if someone begins a medical leave in 2023 and remains out into 2024, they will also have access to the full 12 weeks of FAMLI, assuming the medical documentation supports the time.
Exactly.
Yes.
And so that is just like, nothing an employer does reduces the entitlement to FAMLI. If somebody comes in on January 1st, 2024, and they can show us that they have a reason for 12 weeks of leave that is appropriate under the law, that is available to them under the law, we're going to give them that 12 weeks of leave. If there's something else that they might have received prior to January 1st, 2024, that's going to be between whoever provided that benefit and them. But we will not be reducing family leave benefits based on anything that an employer or another provider has given in 2023.
Thank you, David. And we are at time. So thank you everyone for participating in our webinar. Thank you for all the wonderful questions. Thanks for watching live on YouTube, and thanks to all of our panelists for answering the questions. And I will hand it back over to Tracy for final thoughts.
Thank you so much, Jessica and David. Great work today. We do want to hear from you. Your feedback is critical to the success of our program. As you can see on your screen, you can reach us through social media, through our website, and you're certainly welcome to phone us. We have a fully staffed contact center at 1-866 COFAMLI, CO Family. We are available Monday to Friday, 8 until 4, with weekends and holidays excluded. We will be closed on those dates. We do have our next Facebook Live coming up on July 12th, and there is no doubt that there will be more webinars coming up over the coming months as we continue to share the word about the work that we're doing. Please make sure that you're subscribed to our newsletter. You can do that at family.colorado.gov. We send out lots of really good information on a monthly basis, and I believe there'll be a new episode coming out here fairly soon. So Jessica, how did the poll go?
It went great. I will end the poll if anyone's curious to see the responses, but we will use all of this data in our communications moving forward. So thanks everyone for answering the poll as well.
Great. Thank you all so much. Take care. Have a great rest of your day, and happy 4th.